Hello everyone, we are from Business Law Group 3. Today we are going to talk about intellectual property rights in Canada, in which we are going to cover trademarks, copyright, patents, industrial rights and trade secrets. And we are going to talk about advantages and limitations of each of these, and we are going to also talk about their usage.
This is Saiprit Kaur and my topic is trademarks. So to begin with, I would like to share you the purpose and scope of trademarks. Which helps to differentiate one company product from another company product. The product may be any like words, symbols, sounds, designs, and etc. The Trademark Act manages trademarks throughout Canada. The protections offered by trademarks are like it can only be used for a specific product or services. It stops others from using an identification that is belongs to the another person. The advantages it offers, like it helps to increase consumer loyalty and consumer brand awareness. Trademarks acts as the valuable intangible assets for business, and it allows to take actions against its unauthorized usage through proper means. It offers limitations, like if trademarks are not used for consecutively 3 years, these can be cancelled. Its protections are limited to the specific geographical limits and specific product or services. And last and not the least, it must be unique and it should not be false and descriptive. Thank you.
Patents, concept and scope. A new useful and innovations like machinery, methods and product are protected by patents. These grants help the patent holder to reserve its right and bounded by the Patent Act. So now the protection provided by the patent holder has the right to develop and sell the innovation from 20 years to the date of filing. The sport originally by offering a temporary ownership advantages. After having a patent, it's easier to sell the innovation and it adds legal right to the value of the innovation. Allow to take a legal action to against who uses the product illegally or duplicate the product, and it can be sold or licensed for some value. Now, the limitations of some inventions are not patentable, such as theoretical concept and medical treatment, and during the application process, public disclosure is required, requiring.
Hello everyone, today I am going to present copyrights. Copyright is the one kind of intellectual property right in which it protects the right of the owner by preventing others from copying or modifying the owner's work. It applies to 4 dimensions. First one is literary work, dramatic work, artistic works and musical works. The owner has the right to protect these work only if they fulfill certain requirements. So there are 2 requirements for this one. First one is originality. The work should be original and should not be copied from anyone else. Secondly, the work should be in any fixed form such as paper. Under the copyright law, the registration of the work is not required. It is optional. So like it is an automatic copyright law. And if there is no agreement regarding the ownership of the work, then the author of the work is considered to be the owner of the work. And if we talk about the duration of the copyright is life of the owner plus 50 years. Now we will going to discuss about the rights of the owner. The owner can reproduce his work in any material form. The owner has the right to perform his work in public areas such as not public like publicly, such as singing a song in a concert. If the work is unpublished, the owner has all the rights to publish his work. The owner has right to do trans.
Okay, so my topic is industrial design. Industrial design safeguard a product aesthetic features such as its form, pattern or embellishment. This design improves the product aesthetic, which make the product more appealing and for the market differentiation. If I talk about the example, it includes the Tim Horton roll-up framework design and Lululemon aligned yoga pant. The protection it provides covered innovative and distinctive design which are used in mass-produced goods. It also comprises a variety of goods including textile, appliances, and furniture. If I talk about duration, it is for 5 years, but you can extend it for another 10 years, which include total 15 years. Advantages of ownership: it is a sole authority to sell, license, or even another person can't duplicate the design. It provides the protected, unique product looks, which helps in companies creating a recognizable brand identity. If I talk about limitation, the first one would be you can only like industrial design only the design, not on the functional basis. The second one is scope restriction. You can't make your industrial design overall the globe, only for the territorial based companies. The third one is enforcement issue. It includes a lot of time and cost for to make industrial design, or for the monitoring the industrial design, like is the another company is already established on based on your own design. So that's all about industrial design.
So today I will discuss about the trade secrets. It is a secrets that give an advantage over competitors, and the legal protection, no official registration, confidently and non-disclosure agreement. Key features are it must have a commercial value, demands that reasonable efforts be made to maintain the confidential of information, and the duration of this is indefinite, provide that confidentiality is upheld, and remedies for infringement is legal actions for misappropriation or confidential violations, potential injunctions, damages, or profit sharing. Limitations: no defense is confidentially is compromised, independent discovery and reverse engineering are acceptable.